So let us start. Emergency provisions in the Indian Constitution. Emergency provisions in the Indian Constitution. Article 352 to Article 360. Article 352 to Article 360 of the Indian Constitution deals with emergency provisions. The idea of emergency provisions we have taken from Government of India Act 1935. The idea of having emergency provisions we have taken from Government of India Act 1935. Suspension of fundamental rights during emergency. Suspension of fundamental rights during emergency we have taken from Weimar Constitution, Germany. Two things you have to remember. The idea of emergency provisions we have taken from Government of India Act 1935. Suspension of fundamental rights during emergency we have taken from Weimar Constitution, Germany. During emergency conditions, India, which is actually a federal setup, will turn and act like a unitary model. In the emergency conditions, India and the setups will act like a unitary model rather than federal model. The states are very small. To meet the unforeseen situations, in order to maintain the unity and integrity of India, emergency provisions are created. According to the Constitution, there are three types of emergencies: national emergency, state emergency, or constitutional emergency, or president's rule. First type of emergency is national emergency. Second type of emergency is state emergency, constitutional emergency, or president's rule. Third type of emergency is financial emergency. Article 352, national emergency. Article 356, president's rule or constitutional emergency. Article 360, financial emergency. There are three types of emergencies in India. Okay. First, let us discuss about national emergency. National emergency. When there is a war, external aggression or armed rebellion. Whenever there is a war, external aggression or armed rebellion, then the president can proclaim national emergency. There is no need for actual occurrence of war or aggression. Even an imminent danger is enough. If the president feels that there is a danger of war, it is enough. There is no need for actual occurrence of war or aggression or rebellion. If the president feels that there is an imminent danger, it is enough. And national emergency does not mean that emergency should be proclaimed throughout India. Most of the students think that national emergency have come to India only once, that is 1975 to 77. That is wrong. Throughout India it is only once. For example, recently there is an issue called Doklam issue. If the president really thinks that there is an imminent danger of aggression, he may proclaim emergency for some states which are bordering to China. He may not proclaim emergency in South India. Okay. Don't think that national emergency means emergency throughout India and came only once. It came many times. Okay. Second aspect. President shall proclaim national emergency only when the cabinet gives it in writing to him to proclaim. Here the satisfaction of the president means not his personal satisfaction, but the satisfaction of the cabinet. Cabinet should give it to him in writing. The word cabinet in the entire constitution is used only in one article. The word cabinet in the entire Indian constitution is used only in one article, that is article 352. That too not in the original article but by amendment. By 44th amendment, the word cabinet is used. Cabinet should give it in writing to the president to proclaim emergency. And after proclamation of emergency, within 1 month the parliament has to approve it. If the parliament is not in session, within 1 month after reconvening of the parliament, if the parliament is not in session, within 1 month of the reconvening of the parliament, parliament should approve it with a 2/3 majority present and voting. With 2/3 majority present and voting. When once the national emergency is approved, it will continue for 6 months. When once the national emergency is approved, it will continue for 6 months. After 6 months, if again we want to continue it, the parliament has to approve it with a 2/3 majority again. Okay. Remember, when the national emergency is proclaimed, the life of parliament can be extended. The life of parliament can be extended for 1 year at a time. When a national emergency is proclaimed, the life of parliament can be extended for 1 year at a time. This was mentioned in Article 83, Clause 2. In no case the life of Lok Sabha will be extended. In no case the life of Lok Sabha can be extended. The life of Lok Sabha can be extended only in one case. That is during national emergency. According to Article 83, Clause 2, the life of Lok Sabha can be extended 1 year at a time when a national emergency is in operation. Generally, the maximum life of Lok Sabha is 5 years. Only in case of national emergency, according to 83 Clause 2, Article 83 Clause 2, the life of Lok Sabha can be extended 1 year at a time. According to Article 250, when national emergency comes into existence, the parliament have the power to make law in the state list. According to Article 250, when the national emergency comes into existence, the parliament is empowered to make law in the state list. Okay. Generally, parliament should not make law in the state list. State legislature should make law in the state list. But when national emergency comes into existence, the parliament can make law in the state list. According to Article 358, when national emergency is proclaimed, according to Article 358, when national emergency is proclaimed, Article 19 will be automatically suspended. You may get a prelims question. Which article will be automatically suspended when national emergency is proclaimed? Article 19. But remember, when national emergency can be proclaimed, only on 2 grounds Article 19 will be suspended. Generally, you all know, national emergency will be proclaimed on 3 grounds: war, external aggression, armed rebellion. But only when the national emergency is proclaimed during war or external aggression, not on armed rebellion. Only on 2 grounds when the national emergency is proclaimed, Article 19 will be automatically suspended according to Article 358. when the national emergency is proclaimed on the grounds of war or external aggression, Article 19 will be automatically suspended. Article 359 says, Article 359 says, except Article 20 and 21, very important prelims question, except Article 20 and 21, that means 20, 21 can never be suspended. Article 20 and Article 21 can never be suspended. Except Article 20 and 21, remaining all or any fundamental rights can be suspended by a President's order. Except Article 20 and 21, remaining all or any fundamental rights can be suspended by a President's order. It was written in Article 359. Apart from that, center have the power to give directions to the state, even some executive directions, when national emergency is in picture. 44th Amendment makes lot of changes in national emergency provisions. 44th Amendment was made by Janata government after emergency. So, before 44th Amendment, Indira Gandhi proclaimed national emergency. She has not informed even her cabinet colleagues when President imposed emergency. So, the word cabinet should recommend in writing is inserted by 44th Amendment 1978. Before 44th Amendment 1978, after the proclamation of emergency, the Parliament has to accept it within 2 months. But after 44, the Parliament has to accept it within 1 month. So, 44th Amendment made lot of changes in emergency provisions. Apart from that, Article 352 also speaks about removal of emergency. The President can take away the emergency by a subsequent proclamation, or if the Parliament disapproves it, the emergency ceases to have an effect. And in that, more importantly, if the members of Lok Sabha, 1/10 members of Lok Sabha gives a notice to the Speaker if the House is in session, or to the President if the House is not in session, then it is mandatory that within 14 days, a special sitting should be conducted. In that special sitting, if the Lok Sabha passes with a simple majority that the emergency should be discontinued, then the emergency should be discontinued. It is very easy for the Lok Sabha to discontinue the emergency. If 1/3 members of Lok Sabha gives a notice to the Speaker when the House is in session, or to the President when the House is not in session, then emergency special sitting will be held, and if Lok Sabha with a simple majority says no to the emergency will come to an end. That means it is very difficult to impose emergency, but it is very easy to remove emergency, because emergency is not a positive thing. For that reason, imposition is difficult and removal is easy. In case of national emergency, the most crucial point is, very important case, ADM Jabalpur versus Shivakant Shukla 1975. Very famous case. ADM Jabalpur versus Shivakant Shukla. In this case, see, during emergency between 1975 to 77, preventive detention laws were used very rigorously. Most of the people were detained for various reasons. Many cases were filed in the high courts. 9 high courts said courts can take up the cases and can hear the cases about detention. even during emergency, habeas corpus cases. But when the government appealed to the Supreme Court told, during emergency, Supreme Court cannot vindicate the grievances relating to the habeas corpus petitions. The enforcement of habeas corpus right is not allowed during emergency. This is a judgment which is considered as a narrow judgment where basic right of habeas corpus is not allowed during emergency. This case is called ADM Jabalpur versus Shivkant Shukla. Very famous case during national emergency. Okay, this is about national emergency, Article 352, Article 83 clause 2, Article 250, Article 353, Article 354. These are the crucial articles about national emergency. Okay. Let us discuss about the President's rule. Article 356 of the Indian Constitution deals with state emergency or President's rule. State emergency or President's rule. B.R. Ambedkar said that Article 356 is the dead letter of the Indian Constitution. Article 356 will be the dead letter of the Indian Constitution. But unfortunately, it is the most misused letter in the Indian Constitution. More than 115 to 120 times, I think around 120 times, President's rule was imposed in India. President's rule was imposed in India. For the first time it was imposed in Punjab in 1951. For the first time it was imposed in Punjab in 1951. And for the first time there is an allegation of misuse of President's rule when the then Congress government imposed President's rule by dismissing EMS Namboodiripad government, in Kerala by Jawaharlal Nehru government in the year 1959. The dismissal of EMS Namboodiripad led communist government led to much criticism in the 1959 itself. Jawaharlal Nehru was the Prime Minister of India at that time when the Namboodiripad led communist government was dismissed. Between July 1959, in that period, July 1959, between 1975 to 1979, there were 21 instances. Between 1975 to 1979, there were 21 instances which were considered as misuses of Article 356. 21 instances. And UP, the Uttar Pradesh, is the Indian state upon which the President's rule was imposed for the maximum times. UP, in UP, the President's rule was imposed for the maximum times. 9 times till date, the President's rule is imposed in Uttar Pradesh. After Uttar Pradesh, it is Bihar, 8 times. After Uttar Pradesh, it is Bihar, 8 times. Jammu Kashmir has a record of a longest governor's rule. In Jammu Kashmir, the introduction of President's rule initially is called governor's rule. The longest governor's rule, 6 years continuously. Jammu Kashmir has the record of the longest governor's rule, 6 years continuously. Indira Gandhi government tops the chart. Indira Gandhi government tops the chart of Indian PMs who imposed majority number of president's rules. Indira Gandhi government tops the chart of Indian PMs who imposed the president's rule upon the states. During her tenure as Prime Minister between 1966 to 77, between 1966 to 1977 and 1984, she has imposed president's rule around 50 times. She imposed president's rule in various states around 50 times, 50. And Morarji Desai government in 2 years tenure, from 1977 to 79. Morarji Desai government in 2 years tenure, 1977 to 79, that is Janata government, imposed president's rule for 16 times. President's rule for 16 times. Okay, these are the important data which you should remember before going into actual president's rule. So, Morarji Desai government in 2 years went for 16 president's rules in various states. Indira Gandhi government went for 50 president rules. Till date, I think 124 president's rule in India. There are 124, exact data you have to check it out. 124 around president's rules in India. And Uttar Pradesh tops in the president's rule. In the imposition of president's rule in the states, Uttar Pradesh tops. And the recent Uttarakhand and Arunachal Pradesh incidents are the notorious examples of misuse of power. In the last year's 2016, Uttarakhand and Arunachal Pradesh incidents are the notorious examples for the misuse of president's rule in the states. Generally, if one government is ruling at the center and the different political party is ruling at the state, if a different political party is ruling at the center and a different political party is ruling at the state, rivalries exist and the central party, by virtue of its dominance, can use this weapon of president's rule to control the state governments. Can use this weapon of president's rule to control the weapon of state governments. Use it as a weapon to control the state governments. Okay. Article 355 imposes a duty on the center. Article 355 imposes a duty on the center. That is the duty to protect the states. Article 355 imposes the duty on the center to protect the states. Very important article. Article 356 actually discusses about president's rule. Article 356 actually discusses about president's rule. 356 says, on the report of the governor or otherwise. The report of the governor is not mandatory to impose the president's rule, but generally report of the governor will be sought. But generally report of the governor will be sought for the president's rule. On the report of the governor or otherwise. On the report of the governor or otherwise, president's rule will be imposed in the states. And once the president's rule is imposed by the president in the state, within 2 months, the parliament should approve it. Within 2 months, the parliament should approve it. If the parliament approves it, it will continue for 6 months. To the maximum extent, president's rule in a state can be continued only for 3 years. To the maximum extent, president's rule in a state can be continued only for 3 years. But 44th Amendment made it more strict. The 44th Amendment 1978 made it more stringent. It says, after 1 year, the election commission has to certify that in that particular state, elections cannot be held. The conditions are not congenial for the elections. So, after 1 year, if you want to continue the president's rule in the state, the election commission has to certify that elections cannot be held in that state. Situation is not congenial in the state to conduct elections, or national emergency should be in operation throughout India or in that particular state. National emergency should be in operation. Then only President's rule can be allowed to continue for more than 1 year. So the maximum period is 3 years. There was a special amendment to the constitution with respect to Punjab, where Punjab can have more than 3 years, but now it is not being used. So at max in any state, President's rule can be for 3 years, and for every 6 months the Parliament should accept it. And when the Lok Sabha is resolved before this 2 months, and the President's rule will continue and will cease to effect after if it is not approved within 30 days of Lok Sabha convening. So when the President's rule is imposed in the state, it should be generally accepted by the Parliament within 2 months. If the Lok Sabha is resolved before 2 months, then the President's rule will continue, and after Lok Sabha reconvenes, within 1 month the Lok Sabha should accept. Within 1 month the Lok Sabha should accept. Then only the President's rule will be continued. Otherwise it will have ceased effect. Rajya Sabha, as you all know, it's a permanent body. Within 2 months Rajya Sabha has to accept it. As you all know, Rajya Sabha is a permanent body. Within 2 months Rajya Sabha has to accept it. And as the President's rule is imposed by the state, President has the power to stop its operation at any time he wants. That means at any time government wants, President's rule can be withdrawn. That is also an important factor here. Okay, and the election commission has to certify. The election commission has to certify if the President's rule should be imposed for more than 1 year, that elections cannot be held in that particular state. And during President's rule, the President may proclaim that all the powers has been assumed by himself, or any of the functions of the state, or any of the powers of the governor, and the functions will be exercised by any body or bodies authorized by him, authorized by the state legislature or state executive. And here the President should not touch the High Court issues. The President should not touch the High Court issues. Important point is High Court jurisdiction, High Court matters, the President should not touch, though President's rule exists. Okay, next. On imposition of President's rule. On imposition of President's rule, President may either suspend or dissolve the legislature of a state. President may either suspend or dissolve the legislature of a state and declare that the powers of the legislature of a state shall be vested in the Parliament, and declare that the powers of the legislature of a state shall be vested in the Parliament. Means any policy, anything, then it will go to the Parliament directly. That also the President can do. That also the President can do. When once the generally de facto Chief Secretary will have major powers, and he will be maintaining most of the government records and official policies during President's rule under the guidance of the governor. And when new policy or new thing comes into picture, or any new emergency need to be done, emergency issues need to be done, then the Parliament will take a call. Then the Parliament will take a call. So this is Article 355, 356 and 357. Here you have one more article called Article 365, the most crucial article in the Constitution. Article 365, the most crucial article in the Constitution, that is, if any state government fails to follow the directions given by the center, if any state government fails to follow the directions given by the center, then the center can declare that there is a failure of constitutional machinery in that state. Then the center can declare that there is a failure of constitutional machinery in that state. Remember, Article 365 also talks about failure of constitutional machinery. If the if the central government gives certain directions to the state, if the state government fail to follow certain directions, then the central government may believe that there is a failure of constitutional machinery in that state, and with that guise the central can impose president's rule. In the president's rule, the very important case is S.R. Bommai versus Union of India. The most important case in the president's rule is S.R. Bommai versus Union of India. This case is a case where many cases were dealt together. After Ayodhya incident, many of the state governments got dismantled and president's rule was imposed under Article 356. President's rule was imposed under Article 356. S.R. Bommai case dealt with respect to president's rule, and it told that there can be a judicial review on imposition of president's rule. There can be a judicial review. The judgment in S.R. Bommai's case, is the most crucial judgment with respect to president's rule. Okay. So, the points in S.R. Bommai case everybody has to remember and by heart. The judgment points in S.R. Bommai case everybody has to remember. Just take down. Point number 1. President's proclamation dissolving the state legislative assembly is subject to judicial review. Point 2. If a state government works against secularism, then president's rule can be imposed in that state. Next, there can be no wholesale dismissal of state governments. Without valid reasons. Imposition of president's rule and dissolution of state legislative assembly. Imposition of president's rule and dissolution of state legislative assembly should not be done together. Imposition of president's rule and dissolution of state legislative assembly should not be done together. State assembly can be dissolved only after Parliament's approval of President's rule. Only after Parliament's approval of President's rule. The Supreme Court or a High Court, can compel the central government to disclose the material on whose basis President's rule is imposed. The power of president under Article 356 is a constitutional power, but not absolute power. It can be questioned in the court of law. And the power should be exercised constitutionally. Remember a point. Generally, to take a revenge on the state governments, which are ruled by different political parties, they will impose president's rule, and along with the president's rule, state assembly will also be dissolved. But the court told, you cannot do both of the things together. If things become set right within a week or 2 or month or 2 months, there is a chance of revival of the Council of Ministers there. So you cannot dissolve state assembly along with the imposition of president's rule. And the court can ask the material facts based on which the president's rule is imposed. The court can ask the material facts based on which the president's rule is imposed. And the president's rule is subject to judicial review. As you all know, in the recent Arunachal Pradesh and Uttarakhand incidents, judicial review have taken place. It is subject to judicial review. If the judiciary really feels that the material facts are vexatious or superfluous, even the judiciary can ask the reviving of state legislative assembly. The judiciary told. Even it can ask the reviving of state legislative assembly. The judiciary told. So, S.R. Bommai versus Union of India is a very famous case. S.R. Bommai versus Union of India is a very famous case with respect to President's Rule Article 356. And the last type of emergency is financial emergency. Article 360. The last type of emergency is financial emergency. Article 360. Till date, financial emergency has not been imposed in India. Till date, financial emergency has not imposed in India. And Article 360, financial emergency is not applicable to the state of Jammu Kashmir. Article 360, financial emergency is not applicable to the state of Jammu and Kashmir. Okay, if the President of India is satisfied that, financial stability or credit of India is threatened, for the effective finances and stability of the country, he can impose financial emergency. During financial emergency, state financial bills might go up to central level, up to President for consideration. During financial emergency, the salaries of civil servants, judges can be reduced. So, till date, no financial emergency in India. So, this is about Article 360. So, we have 3 types of emergencies. Article 352, Article 356 and Article 360. 352 is national emergency, 356 is President's Rule, 360 is financial emergency. So, in 352, we have 3 grounds: war, external aggression, armed rebellion. Earlier, there is war, external aggression and internal disturbance. By 44th Amendment, the word internal disturbance was removed and armed rebellion was added. By 44th Amendment, the word internal disturbance was removed and armed rebellion was added. So, in India, there are 3 types of emergencies: national emergency, President's Rule and financial emergency. This is all about emergency.